These are certain current affairs topic which is there chosen for specifically for prelims. Okay, so this was a document which was already shared, but we have removed all the mains content and only kept to what is related to prelims. So here we'll go certain important issues and value additions. What is there on the document? What will be required for your upcoming prelims? So we'll need 2 classes to cover it. So today we'll cover half, and in one more class we'll cover the other half. So now, first issue if you take, this had come in like, this is 1 year's current affairs. So this is the 75th year of what you can say, the constitution coming into being, that is 26th November 1949. So now if you look at, there was an article in Hindu which spoke about who were the important women who are part of Constituent Assembly. So of course you don't need to know about what they contributed on. For prelims, largely facts should be known. So one of the important fact here you have to know is that Dakshayani Veluyudhan was the first and the only Dalit woman in the Constituent Assembly. So there is one name that you'll have to know, that what is that? Dakshayani Veluyudhan. She was the first and only Dalit woman in the Constituent Assembly. Same way you have to know about Begum Aziz Rasul. She was the only Muslim woman who was part of what? The Constituent Assembly. So you can't remember so many names, but certain names which we can pick and we can remember. So in general you have Hansa Jivrad Mehta, Ammu Swaminathan, Annie Mascarin, Leela Roy, Durgabai Deshmukh, Rajkumari Amrit Kaur in that regard, Sarojini Naidu, and here the first woman cabinet minister who was also part of the Constituent Assembly was Vijay Lakshmi Pandit. Okay, and the first woman chief minister was Sucheta Kripalini. So these are certain names that you need to remember in prelims, or a question can be also asked, identify which of the following women were part of the Constituent Assembly. So this was information that was given in what? Hindu newspaper. So these are the names that you will have to remember. So remember, Dakshayani Veluyudhan, the first and only Dalit woman in the Constituent Assembly. Begum Aziz Rasul, the only Muslim woman to be part of the Constituent Assembly. Vijay Lakshmi Pandit, the first woman cabinet minister and a politician, a diplomat, etc. And Sucheta Kripalani was the first woman CM to be part of the Constituent Assembly. Okay, other things are all not important because you can exclude. These are only doing from prelims point of view. And the same way if you look at here, these are certain important dates that you can remember regarding the Constituent Assembly. So one, you have the first meeting of Constituent Assembly was on December 9th, 1946. Rajendra Prasad got elected as the first president on December 11th, 1946. Then you have on August 29th, 1947, the drafting committee was appointed. And you have November 4th, 1947, the draft of the constitution was submitted. And then you have November 26, 1949, the drafting was completed, means it was passed. And finally, if you take, the handwritten constitution was signed on January 24th, 1950, and finally it was passed on, means came into effect on 26 Jan 1950. So it took almost 2 years, 11 months and 18 days to make the constitution. So in sometimes prelims what they can do, they can also go factual. They can say match the following, or they can ask on which day the constitution was, handwritten constitution was signed. So some of can also go on 26 Jan, it was not 26 Jan, it was 24th Jan 1950. And you also have to know that it's not that all parts of the constitution came into effect on 26 Jan 1950. There were some parts of the constitution like linked to citizenship, elections, which came even beforehand. And other thing you've already known that the Constituent Assembly came into being on the recommendation, on the cabinet mission plan. For the first time the British offered the Constituent Assembly was when? It was the August offer. Okay, then it was the Cripps proposal. So these are the information that you can remember. That's why in prelims you need to remember certain things where you can say, and that's why I told, current affairs does not always mean it has to be something which is current. You have to know the context under which what is in news. Now next issue, if you take, the secularism has been constant in news. Okay, so you can say that Supreme Court again said that secularism is an inedible and core part of the basic structure of the Constitution. So two types of question can come here since it has been in news in that regard. One question they can ask, what is the difference between Indian secularism and Western secularism? Again, go back to your just basics. Western secularism, complete separation of state and church. Indian secularism, there is no complete separation of state and church. Western secularism is also called as negative secularism. Here we also call it as positive secularism. In Western secularism, they'll only recognize individual rights. Community rights are not recognized. Here, both individual rights and community rights are recognized. And the type of secularism what we follow in India, it is based on principal distance model. It is not based on equidistance model. And for the first time when they declared secularism as part of basic structure was S.R. Bommai case. These are the facts that you'll have to know for prelims. If you know these for prelims, you'll be able to answer any question. Means I am telling they might ask questions in different sentences. So if you look at what are the core features secularism in India promotes, it promotes, upholds equality, tolerance towards all religion. It prohibits any kind of discrimination. It also upholds democratic values in that regard. Social harmony, protection of minority rights. So they might ask a question, which of the following are the aspects of Indian secularism? Why? Because this question has been, this secular issue has been coming in news in last 1 year in multiple places. And two important cases also we can remember apart from connected to secularism. Bijoy Emmanuel case versus state of Kerala, where they told right to silence is also part of your fundamental right. And you have Shafin Jahan versus Ashokan KM and others 2018, that is popularly also called as Hadia case, where they said right to marry a person of your choice is a fundamental right under Article 21. But in prelims, they can confuse you by asking, is saying that right to marry as a fundamental right is applicable to all sections of Indian society, then it is incorrect. Why? Because the Supreme Court has not recognized right to marry between the same sex couples. It does not apply to them. So same sex couples, for them, right to marry is not considered as a fundamental right. I think in one of the vision test series they've asked this question in that regard, whether the right to marry is applying, it's an unqualified right. The word they've used is unqualified right. So there, that's why I told many times English should be important. What do you mean by unqualified? It means it is applied to everybody. No, it is a qualified right. Right to marry in India is not an unqualified right, it is a qualified right. Why it is a qualified right? Because it is not applicable to homosexuals. So they have decriminalized homosexuality, but they have not given the right for homosexuals right to marry as a fundamental right. The court has told you have to approach the parliament and let parliament bring a law. Got it? So remember, that was in Shafin Jahan case, that is, or the Hadia case, where they told right to marry is part of Article 21. And please remember, it is not what? An unqualified right. It is a qualified right. Qualified meaning what? It is applicable to certain sections. So for example, right to vote, it's not an unqualified right. It's a qualified right. Everybody does not get right to vote. Your name should be registered in the voters list for you to first of all vote. So it does not mean every citizen of this country has right to vote. So that's what we say, that when we say you revise current affairs, it does not mean randomly picking up current affairs and just by hearting facts. You will also have to link the background and the basics what you have read. Now, the path towards a civil society. Okay, here I don't think so. Okay, here. So in this article, it's an article which was come here in newspaper. So in prelims paper, they've asked lot of times difference between Gandhi and Ambedkar, the philosophies or principles. This can be mainly asked from your NCERT part. So please remember important views of Gandhi on constitution. Gandhi's principles: one, he believed in what? Decentralization. Second one, strong advocate of non-violence and truth. Second one, Swadeshi and self-reliance and religious harmony. And you can say most of the Gandhian provisions in the constitution has been reflected in directive principle of state policy. But we cannot tell it just only DPSP. There are Gandhian provisions, Article 14, Article 15, Article 17 also espouse Gandhian philosophy. On the other hand, when you look at Ambedkar in that regard, so he was a person who believed in the Western idea of secularism, that is separation of the state from the church, not the Gandhian idea of secularism. And you can say he also brought the idea of what affirmative action, that is what positive discrimination in favor of the weaker section, or what we call as the untouchables or the depressed classes of Indian society. And social justice was other core component of Ambedkar's ideas. So in prelims they have asked previously common things between Gandhi and Marx. They can also ask between Gandhi and Ambedkar. So remember, for Marx, what is not common between Gandhi and Marx, or what is common between Gandhi and Marx? One thing common between Gandhi and Marx: both believed in a stateless society. Okay, but there were differences. Marx believed in violence, Gandhi did not believe in violence. Marx believed in this industrial large scale industries. Gandhi was more believing in small scale industries. Marx never believed in the idea of religion. He told it should be irreligious, means religion should be banned, whereas Gandhi believed that you can't separate religion and the state. So here one article had come in newspaper regarding what this Gandhis and this thing. And same, this is a repeated article, as we told, the Indian concept of secularism and Western concept. But there is one term what they used in this newspaper article called as secularization. Okay, so in prelims they can ask, what do you mean by secularization? And is secularization and secularism one and the same? It is not the same. Secularism refers to what? The state not discriminating between any religion, or in Western sense separation of state from church. Secularization is a process where the role of religion in society will start to decrease. You are moving more towards rationality or rationalism. That we call as what? Secularization. So take down the word. See, the word secularization is a social process where loss of belief in religious doctrines, ceasing to carry out standard rituals, changing diets, hence and so forth. That we call as what? Secularization. In simple terms, secularization is a process where the role of religion in a society will start declining. That is what we call as secularization. That is why some people say India is a secular state, but the society is not yet secularized. Why? Because within the society still religious customs, traditions, they still play a larger role. But if you look at the Western countries, especially after Renaissance, the process of secularization happened, where they automatically started reducing the role of religion in their social process. So secularization is more connected to society part. Secularism is more connected to the state part. That's the difference between secularism and secularization. So certain times we'll tell how prelims they'll pick some bits and pieces of some editorial pages. They can ask in prelims, what do you mean by secularization? Please remember, secularization is a process of declining role of religion in a society. Okay, other things and all don't read now. You read it for mains when it is required. For prelims only I am telling what is important. Okay, as I told, SR Bommai case 1994, for the first time when the Supreme Court declared secularism, federalism and parliamentary democracy as part of basic structure of the constitution. And as you know, the doctrine of basic structure has been not mentioned in constitution. For the first time the court came out with this doctrine in Keshananda Bharati case. Now there was this in Ladakh, this climate activist Sonam Wangchuk. He wanted Ladakh to be included under 6th schedule. So let's look into, okay, first of all, which are the states currently under 6th schedule? Arunachal Pradesh, Tripura, Meghalaya and Mizoram. These are the 4 states, not the entire state, parts of the states under 6th schedule. Now they are asking what? Ladakh to be brought under 6th schedule. Who can bring Ladakh under 6th schedule? It is the center. Okay. So now if you look at the constitution has 2 schedules, 5th schedule and 6th schedule, and you have to know what is the difference between 5th schedule and 6th schedule. So if you look at here, the 5th schedule, it deals with administration and control of the scheduled areas, okay, where certain tribal population are there. 6th schedule, it deals with tribal areas in only 4 states. 5th schedule is currently applied to 10 states in India. So you have Chhattisgarh, Jharkhand, Maharashtra, you have Madhya Pradesh, you have Gujarat, okay, these states. Karnataka does not come, Telangana. So they might not ask all the 10 states, but logically, you know, there are 10 states which come under 5th schedule, and that entire state does not come under 5th schedule. Parts of these states come under 5th schedule. And same way here, if you look at the what is that? There are, apart from 5th schedule and 6th schedule, there are some states in northeast which also have special provisions. Okay, apart from telling 6th schedule, there are special provisions. Like if you take Article 371A, that applies to what? Nagaland. Article 371B, that applies to what? Assam. Article 371C, that applies to Manipur. 371F, Sikkim. 371G, Mizoram. 371H, Arunachal Pradesh. So many times in prelims we tend to ignore the factual information, but many times these factual information can be asked, because Mizoram or Manipur currently is in news. Okay, so they might interlink or ask something, like they might give in your one of the sentences saying that Manipur has the benefits under Article 371G. It is not G, it is C. Karnataka also has, Hyderabad, Karnataka, 371J. And who can bring this? Parliament. Through what? A constitutional amendment. So remember, A is Nagaland, B is Assam, C is Manipur, F is Sikkim, G is Mizoram, H is Arunachal Pradesh. Speaking about northeastern states. Now, here you can say, what are the benefits of bringing under 6th schedule? They will establish district autonomous councils, and these district autonomous councils, they have legislative powers, they have executive powers, and they also have certain judicial powers. These are important points you need to remember. Okay, and one more point you need to remember: PESA, that is Panchayat extension to scheduled area. It is only applied to 5th schedule areas. It is not applied to 6th scheduled areas. And PESA was brought when? 1996. Understood? So remember, scheduled areas, tribal areas. And one more point, I think last time only I have discussed. It is possible by the president through an order also establish a tribal advisory council in a state which does not come under scheduled area. So in prelims they might ask, tribal advisory councils can be only created in those states which have scheduled area. Please remember, president can also create a tribal advisory council in a state which does not come under 5th schedule, that he has to pass an order in that regard. So recently they have created in West Bengal. Okay. Now here, one more information. That's all. In one article you might get not all the information. Like which committee they might ask had recommended this 6th schedule to the constitution. Please remember, it was Bardoli committee. So Bardoli committee was a committee that recommended 6th schedule to be added into the constitution in that regard. And one more important information you have to remember is that in Ladakh, tribal population constitute 97% of their population. In Ladakh, tribal population constitute 97% of their population. And you can, as I told you, district autonomous councils, they have legislative, judicial, financial powers. All the 3 powers are enjoyed by them. And please remember this fact, in Ladakh 97% of the population are tribal population. Now here certain other, again, application of 6th schedule, means within 6th schedule we have to look at how do they go. So as I told, this comes under what? Article 244 clause 2 of the constitution and article 275 clause 1 of the constitution. So in Assam you have certain regions. So you take hill district of Dima, Hasau, Kabri, Anglong, and Western Karbi, and the Bodo territorial region. These are the regions that comes in Assam under 6th schedule. And governor here, it means here in these states, governor is empowered to increase or decrease the areas or even change the name of the councils. So they might ask, who has the power to increase or, see, it is going to be the president who is going to declare them. But who has the power to increase or decrease the area? It is the governor. Okay. He can also change what? He can also change the names of the autonomous districts. And here you can say the powers of the union, that is the central government, is extended in scheduled areas. Where is scheduled areas? 5th schedule. But please remember, that is in 5th schedule. In 6th schedule, they remain with the executive authority of the state. The key point, the executive powers of the union government extends to the 5th schedule, means they can give directions there. But the executive power of the union government does not extend to the 6th schedule areas. They remain with the state. That is one key point you also have to remember with regard to what? 6th schedule. And here, one more key point. I told judicial powers are there. What kind of judicial powers? Is it only civil or criminal? They have both have civil and criminal jurisdiction, but it's not going to be serious criminal cases. The petty criminal cases can be sorted out by the district autonomous councils. So these are the important points that you have to remember. Please remember, governor in a 6th schedule area can increase or decrease the area, change the name of the autonomous council. And the other key point, the executive powers of the union government extends to 5th schedule areas. It does not extend to what? 6th schedule areas. So here if you see that 5th schedule, scheduled area, 6th schedule, tribal areas. Then you have tribal dominated areas in 10 states. That is Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha and Telangana. These are the 10 states that come under 5th schedule. That is, you know, that 4 states. And here they create what? Tribal advisory committees. And tribal advisory committees do not have much autonomy and they do not perform much administrative functions. Whereas you have autonomous district council, they have autonomy in that regard. PESA is extended to 5th schedule. PESA is not extended to 6th schedule. And these are the regions, like in Meghalaya, you have Kasi Hill Autonomous District Council. Then you have Jaintia Hill Autonomous District Council, Garo Hill Autonomous District Council. In Mizoram, Shakma Autonomous District Council, Lai Autonomous District Council, Mara Autonomous District Council. So sometimes in prelims they will also have Lai, Mara, Chakma. This comes under which state? So please remember, it is Mizoram. Tripura you can easily remember, Tripura Tribal Areas District Council, Dima Asav, Karbi Anglong and Bodo Land. These all come in Assam. So many times in prelims, if you don't know the full name also, you can remember Chakma, the tribes which are found here. Okay. So these information you need to remember regarding the areas that come under 6th schedule. Get a point? So as I told, reading current affairs, meaning that what? It's not only what you have read in prelims multiple times, will be some information which might not be there in Lakshmikant. Or there will be some information when you understand through context, that under what context it is, you will have a better understanding of issue and the number of mistakes what you are going to do will reduce. Then if you look at here recently, there is a recent judgment by the Supreme Court. The Supreme Court has upheld the power of the municipal councils to levy the terminal tax within the limits of scheduled areas. So meaning that the question was that, do these bodies, the municipal bodies within these scheduled areas, do they have taxation powers? So the court, the parliamentary or state law won't apply to 6th schedule area only if the governors notifies so. And they have upheld the powers of what? They have upheld the powers of local bodies to impose taxes. And you can say the 5th schedule grants the governor the power to direct whether a parliamentary law or a state law will not apply to scheduled area or it will apply with certain exceptions or modification. This is one of the powers that has been granted by the constitution to governor of what? 5th schedule states. And now on what basis they will consider to declare a scheduled area? So president is a person who is going to add a scheduled area, but what is the criteria for it? For that you have to know that these are general criteria taken. One, preponderance of the tribal population, means there should be population of the tribal. Second one, compactness and reasonableness of the size of the area, means it should be a small region. Third, underdeveloped nature of the area. Fourth, there should be disparity in economic standards of people living in this particular area. But please remember, none of these are mentioned in constitution. These are something which have become well established. Now these principles has been based on what we consider as excluded or partially excluded areas under the Government of India Act 1935. And also the Schedule B recommendations of the excluded and partially excluded areas subcommittee of the Constituent Assembly. Based on all these recommendations, these principles have been derived. These principles are not mentioned in constitution, but these are the parameters that are considered while declaring an area as a scheduled area or not. So what is the area? Preponderance of tribal population, compactness and reasonableness of the area, And third one is what? Underdeveloped nature of the area. Fourth one is what? Mark disparity. In means people should be relatively economically poor in this region. And these are different schedules which are there in the Indian constitution, because sometimes the UPSC can also spring a surprise by asking a match the following question, a basic question. So many times what will happen, we'll know a lot of things, but basics only we will not know. So scheduled 1 is linked to what? States, union territories name and boundary details. Schedule 2 is related to what? Salaries and allowances of president, governor, speaker, deputy speaker of Rajya Sabha, Lok Sabha, and Supreme Court and High Court judges. And then you have schedule 3, oath and promises of almost all the constitutional authorities except the president and the governor. So remember, in schedule 3 there is no oath of president and governor. Schedule 4, Rajya Sabha, number of MPs who are in the state. Schedule 5, as we have discussed now, that is scheduled areas in 10 states. Schedule 6, autonomous district council in 4 states. Schedule 7, union list, state list, concurrent list. Please remember, there is nothing called as a residuary list. The schedule 7, any subject which is not found in any of this list, that is considered as what? Residuary list. Then schedule 8, it is official languages. So recently also they have added lot of language into classical languages. So there keep an eye on it to make a difference between which is a classical language and which is a scheduled language, because they can mix up and they can ask which has been added. So how many scheduled languages are there currently? How many? 22. How many classical languages are there? It is 11, because recently they added 5 more. And then you have schedule 9, that is what? Those laws which are placed under 9th schedule, you will keep it beyond the scope of judicial review. But in which case the Supreme Court said it can be questioned. IR Coelho case. And schedule 10, it is reflected what? Anti-defection law. Schedule 11, powers and functions of Panchayat. Schedule 12, responsibilities and powers of municipalities. These are the 12 schedules in the Indian Constitution. Now, the other issue which was there, this section 6A of Citizenship Act, which was in news, which was challenged in Supreme Court. So what is section 6A of the Citizenship Act 1955? So this allowed what? Those people who have migrated from East Pakistan, or what we call as today's Bangladesh, from 1966 up to what? March 25th, 1971. So within this period who have come into the country, they were given citizenship. Those who have come after 1971 will not be given citizenship. So those people who have come during this period, under section 6A, they did provide, we are going to give you citizenship. And this was challenged in court, saying that it is violating Article 14 of the Constitution. It is also violating Article 29 of the Indian Constitution. So what was the challenge they told under Article 14? Article 14, right to equality. Why it is only applied for Assam? Why not for other regions? Article 25, too much influx of these Bengalis into this region will take away the local culture, that is Assamese. But the Supreme Court did not agree with the argument, and they told there is no violation of Article 14, there is no violation of Article 29, and they told presence of just another ethnic community within the state, that alone cannot be taken as what? Violation of Article 29. Hence they upheld the constitutional validity of section 6A. So basically in prelims they can ask the date. In KPSC prelims they have already asked the date. Or they can ask that it is applicable to whom? Applicable to people who have migrated from East Pakistan, or present day what we call as Bangladesh, into India. And it was expected to violate which article in the Constitution? 14 and 29. So what is 14? Right to equality. What is 29 in that regard? Protection of culture rights. So if you look at here, one more law for prelims you have to know, CAA. This is different. So CAA allowed what? Those who have migrated, even illegally migrated, into Indian territory before December 31st, 2014, belonging to 6 communities, that is Hindus, Parsis, Jain, Buddhist, Christians and Sikhs, they will be given citizenship through the process of naturalization, and the time period was also reduced from 11 years to 6 years in that regard. So 6 plus 1 it will be taken. So 6 years it has been reduced. So that is what you can say is under CA, that is non-Muslim communities. Muslims were kept apart. Why? Because they are majority in Pakistan, Afghanistan and Bangladesh. So this law only applies to 3 countries: migrants from Pakistan, Afghanistan and Bangladesh. And okay, so these are the things that you'll have to remember. Now if you look at the eligibility criteria, again same thing, as you know, you should be residing in this country for what? Not 11+1, that is 6 years, okay, because in naturalization it is 11 years, but here they have reduced it to 6 years in that regard. And here, what is the one more point? Okay, that is the same point, Article 14, and how it is connected. And remember, the Constitution does not define that how can you get citizenship and how can you lose citizenship. The Constitution says that the power has been given to the Parliament, and Parliament through a law can mention that how you can get citizenship, how you can lose citizenship, what are the different ways you can acquire citizenship under Citizenship Act 1955, birth, descent, registration, naturalization, acquisition of a territory, and now CAA. And what are the different modes through which you can lose your citizenship? It is for renunciation, termination, and deprivation. Okay, and remember, state assemblies do not have any role in this regard because citizenship is a union subject. Now, one more issue that has been in news is this OBCs and subcategorization OBCs. See, for mains, don't go into arguments and counter, that is useless. For prelims. For prelims, you have to just know about certain facts and what is it. So here, if you take the word OBC in that regard, so this was an expression which was denoted to say that who are backward apart from SCs and STs. But the word OBC is not defined in the Constitution as per se. And you can say that for OBCs, affirmative action has been provided in the Constitution both under Article 15 clause 4 and Article 16 clause 4. Article 15 is related to educational institution and Article 16 is with regards to what? Public employment. When you say educational institution, it also includes private educational institutions also. The first commission that was appointed for backward classes was the Kaka-Kelkar Commission 1954. Same way, if you take the second commission that was appointed for OBCs was the Mandal Commission. It was appointed by then Morarji Desai government, but its report was accepted by whom? The VP Singh government in 1990. And the Mandal Commission had identified how much? 3,743 castes as backward apart from SCs and STs, and they had also told 52% is the population of OBCs. But please remember here, Mandal Commission did not do any survey, caste survey was not done. The last caste survey was done in India when? 1931, back in British time. The Mandal Commission only used the extrapolation of the data, what was there, and they told approximately it is 52%, and they recommended how much reservation? 27% reservation to the OBCs. But at that point of time, the commission had not recommended any subcategorization of OBCs. So please remember, Mandal Commission had not recommended any subcategorization of OBCs. And it was the central government in 2017, under Article 340, they constitute Justice Rohini Commission, because President has the power to appoint any commission to. And Justice Rohini Commission was given the task of determining whether we have to bring subcategorization under OBCs. So now I won't go into the logic that is it good or is it bad, etc., because here only we have to know for prelims facts, because good or bad is more of a mains area, you can bring argument. But the Rohini Commission has given its report, but the government has not made the report yet public. Okay, so it was Justice Rohini Commission, please remember, appointed for what? Subcategorization of OBCs 2017. And it's not that we don't have subcategorization, already you have Andhra Pradesh, Telangana, Puducherry, Karnataka, Haryana, Jharkhand, West Bengal, Bihar, Maharashtra, Tamil Nadu. These states have already brought subcategorization with respect to their state government jobs. Because in prelims they can ask, no state in India has subcategorization of OBC. No, already 9 states in India have brought subcategorization. We are speaking about now subcategorization at central level also. Okay. And see, this was one of the observation of Rohini Commission. Rohini Commission found that only 1.5% of the listed OBCs in that regard has cornered over 50% reservation of jobs, and about 20% did not get any reservation between 2014 to 2018. Andre, only few elites under OBCs, they are cornering all the jobs. The other backward OBCs are not able to. That is one of the reason why they are speaking about subcategorization. So please remember, Kaka Kelkar Commission, Mandal Commission, Justice Rohini Commission, it is related to what? What was the recommendation of these committees? And also please remember, OBCs is not defined in the constitution, it is only mentioned. And this was a case law which was related to what? Dignity versus practicing your religious and cultural rights. That is the Annadanam and what is that? Anga Pradakshanam. So the Supreme Court upheld both things, saying that it is not a violation of individual dignity. It can be enjoyed by Article 25, Clause 1 of the Constitution. So here one of the things what the court said is that right to privacy, it not only includes gender and sexual orientation, it can also include spiritual orientation in this particular judgment. It not only indicates your gender orientation, it also means spiritual means you can spiritually connect with God anyway. And they also tell that as long as the Rubicon is not crossed, meaning that you can practice your customs and tradition as long as you don't violate equality and human dignity, that is allowed to be practiced, and they have upheld these laws. So please remember here, this brings us to the question of the doctrine of essential religious practices. This is not there in the constitution. For the first time it was mentioned in which case? The Shirur Mutt case. And how this doctrine is determined? Nowhere it is written. It is generally practice. So what is the practice here? The judiciary can look into the sacred texts. The judiciary can consult religious experts in that particular area. It can also question when this custom started, whether this was recommended by the founder of the religion, whether this practice is going to violate any of your other fundamental right. Only then they are told it can be allowed to be practiced or not. So remember, doctrine of essential religious practices not mentioned in constitution. And Article 25, it says what? Right to profess, practice, propagate, and what? Profess, practice, innondeno vartala. Profess, practice, conscience of your thing. So Article 25 gives rights to individuals. Article 26 gives rights to groups or community. 25 to 28 is connected to freedom of religion in the Indian Constitution. Now here this is linked to delimitation and women's quota. So here women's quota is not required because yet it's to be implemented, but what we have to know from prelims point of view is delimitation. So one, please remember, delimitation commission is a statutory body. Delimitation commission should be appointed after every census, decadal census. Who will establish delimitation commission? Parliament through a law. Till now 4 delimitation commissions have been appointed in India: 1952, 1962, 1972, 2001 or 2002. After that we have not appointed delimitation commission. And how many members will be there in delimitation commission? 3 members. Who is the head of the commission? A retired CCJ. Then it will have the chief election commissioner and the electoral officer from the respective state. And the commission will bring what? Re-alteration of boundaries as well as re-allotment of seats, means increase or decrease in the number of seats. And the report of the delimitation commission will be submitted to the parliament. So to president, and president will place in the parliament. It can be discussed, but it cannot be voted or it cannot be amended. And the delimitation commission report cannot be challenged in any court. The report is final and it is binding in that regard. And delimitation is done for whom? Lok Sabha seats as well as MLA seats, not for Rajya Sabha. For Rajya Sabha it is 4th schedule. There you will have to bring a constitutional amendment to bring any kind of change. And delimitation currently for Lok Sabha seats is based on which census? 1971 census. For re-alteration of boundaries, it is based on which census? 2001 census. And please remember, 42nd amendment and 84th amendment. 42nd amendment 1976 brought a 25 years freeze on the increase in number of seats till 2001. Again in 2001 they brought 84th amendment to again extend the freeze by another 25 years, that is 2026. These are all the basic information that you will have to know regarding delimitation. I am not going to again positives, negatives, we don't need it for prelims. For prelims only we have to know facts. Why? Because as I told, prelims is a what? Objective paper, it is not a subjective paper. And that's why I told why you need to know about this, because it has been in use. Consistently it has been used from last 1 year. So here the question about article 31C which was there. So now what is the simple case here I will tell. The Supreme Court examined whether the state can take over any private property for its common use. Okay, because under article 31C you have to go back to what it says. First of all, basics will go. Article 31C was added into the constitution by which amendment? 25th Constitutional Amendment 1971. The 31A and 31B, they were added by the first amendment 1951. So what is 31A? What is 31A? There are 5 set of properties or laws on which the parliament or state assembly will bring a law. That law cannot be challenged in court for violation of fundamental right. That is violating 14 and 19. What is 31B? Any law that is placed under 9th schedule is beyond the scope of judicial review. But as we discussed in IR Coelho case, the Supreme Court told no, it can be challenged because judicial review is the basic structure of the constitution. But however, they told we won't look into those laws which are placed before 24th April 1970, because 24th April is the date on which the Keshavan Bharati judgment came. Now what is this 31C which was added by the 25th amendment 1971? What is there in 31C? What is there in 31C? So that's what I told. See, many times you will tell current affairs. If you don't revise your basics, this is connected to current affairs because it's a current issue. It says that when the parliament brings a law to implement those provisions mentioned in directive principle of state policy, article 39 clause B, article 39 clause C. 39 clause B and clause C is connected to what? One, prevention of concentration of wealth. Second one is to what? To ensure that the resources are used for common good for all. So now here the issue was that can the government or state acquire all the private property? So here the court told you can't acquire all the private property. Such a private property that is only as a common good element part of it, only those can be acquired. You can't randomly go and acquire all private property. That was the judgment that was given by Chandrachud, and this is a change in the previous position that was taken by the Supreme Court back in 1997. Understood? This is a new position. Before Chandrachud retired, this was one of the judgment he gave. The court has overturned it. And here you also have to know, when this law was brought, this amendment was brought, what in 1971, 25th amendment, this got challenged in court. That is only the Keshavan Bharati case. So in Keshavan Bharati case, what the court told, they told we'll agree with that first part of your 25th amendment. Yes, parliament does have the power to bring a law to implement what is there mentioned in 39B and 39C. That will allow it. Means where it is violating 14 and 19, we won't question it. But they said you cannot tell, you can take away the power of judicial review, we will have the power of judicial review. Meaning we will evaluate whether that law what you have brought really it implements what is mentioned in 39B and 39C. If really it implements, we will allow it. Otherwise we will strike down it as unconstitutional, and that is why in Keshavan Bharati case what they told, Parliament has the power to amend any part of the constitution including the fundamental rights, but if any constitutional amendment is violating a fundamental right that is considered as part of the basic structure by the courts can be declared ultra vires or unconstitutional. Got it? And remember in Keshavan Bharati case they also said constitutional amendment is not considered to be a law under article 14 of the Indian Constitution, sorry, article 13 of the Indian Constitution. So these are all the background of this issue what is there, okay. So that's all, this is what the current issue was, and that is why you have to know about 31C, 31A, 31B, 25th Amendment 1971, First Amendment 1951, Keshananda Bharati judgment, IR Coelho case judgment, all these things you have to know, okay. Now here, in one of the judgment, that is because this what is that, State of Madras versus Champaka Dorarajan case was quoted in one of the cases recently, and you can see in one of the newspaper very recently also, before also they had given in newspaper. There the Justice Chandrachud had underlined the concept of substantiative equality. So this can be one of the concept question that can be asked in your prelims paper. What is the difference between procedural equality and substantiative equality? Simple. Procedural equality also means what? Formal equality. Substantiative equality means what? It is not just a formal idea of equality. Formal idea of equality means absence of discrimination. Substantiative equality means what? Not absence of discrimination, treating equals equally, unequals unequally, meaning you will have to bring affirmative action. What do you mean by affirmative action? Positive discrimination. When you say that discrimination is positive, when it is favoring the weaker sections of society. So in substantiative equality, it is nothing but, in other terms, equity. Understand? The principle of equity, the principle of substantiative equality are all one and the same. So the idea of equality that has been reflected in the Indian preamble, it is not just procedural equality, it is also what? Substantiative equality. Now the context, in which context Justice Chandrachud told, please remember this case, State of Punjab versus Davinder Singh 2024. Now this case was connected to subcategorization among SCs and STs. For the point, in that case they gave the idea called as what? Substantiative equality, subcategorization among what? Scheduled caste and scheduled tribe. And what was the case? State of Punjab versus Davinder Singh 2024. Got it? What do you mean by it? So here see, they have also spoken about 1992 Indira Sahni judgment. Just a recap of Indira Sahni judgment. 1. The Supreme Court upheld the 27% reservation given to the OBCs. So now what it happened? Now apart from SCs and STs, even OBCs will get reservation in employment and education. Second, they told the total reservation ceiling 50%, but in exceptional cases it can be thing. Third, they said creamy layer has to be brought to what? OBCs. What do you mean by creamy layer? Those who are economically well off among the backward classes, they have to be removed from the category of getting reservation. Means now only you are eligible for reservation if you come under OBC, but you have to belong to what? Non-creamy layer. If you belong to creamy layer, you are removed. And they also tell reservations in promotions cannot be given. They declared it unconstitutional for the scheduled caste and the scheduled tribe. Now, bit forward, Parliament brought an amendment overturning the Supreme Court decision with respect to SC, ST reservation in government jobs, where they told no, we can give, means under Article 16 clause 4, reservations in promotions can be provided. This got challenged in Nagraja case. In Nagraja case, the court told you can give reservations in promotion to the scheduled caste and scheduled tribe, but what? There are 3 conditions. What are the 3 conditions? 1, that community should be backward. Second one, you have to have data to prove that community is backward. Third one, giving them reservation in promotion should not affect the efficiency of the administration. So please remember, nowhere in the constitution the word efficiency of the administration is mentioned, neither it is defined. Fast forward again, Jarnail Singh case, Supreme Court told what 3 criteria we mentioned in Nagaraja case is not required. You can give reservations in promotions in SCs and STs. And they have also upheld what? The catch up rule. Sorry, no. They told what is that? Not catch up rule. What is that? the consequential seniority, and second one they also told carry forward rule will apply. Carry forward means if a particular position is not filled in by SC and SC because there is lack of candidates, you have to transfer it for next year. So these are the things you will have to remember. Nagraja case, Jarnail Singh case, Indira Sani judgment. What was the Supreme Court judgment in Indira Sani? These are the things. Because what is happening in polity, they are not only asking from Lakshmikant, they have also started asking on case laws. They have also asked in recent years. So you take 2023 paper, they have asked this question on Nagraja case, not directly, indirectly they have asked. Assertion and reasoning question, there is one question on Nagraja case. Got it? Remembered? So these are all there in the document, I will share, but as I told, you need to revise and you have to remember things. So here, this was a judgment. Now this is not so important, a simple thing. So we say that even though the constitution abolishes all type of caste, in India till very recently, that was the October 3rd, 2024 judgment, the Supreme Court put an end to the caste based division of labor in prisons. So even until 2024 in India, in prisons, they used to give jobs in prison, means what work you have to do based on your caste. So for example here, if you look at in Madhya Pradesh, according to their jail manual in 1987, the prisoners from Mehtar caste, which was a scheduled caste community in Bihar, they were specifically assigned the work of cleaning toilets. They are not assigned to any other caste, only for these caste. And similarly, we take in Bengal code rules 1967, food shall be cooked by whom? By a suitable caste. So you cannot assign anybody to do the food work, it will be a suitable caste. But now the court ended all this, saying that this division of caste cannot be followed under prison rules. And you can say here, why we say in prison rules, because prison is a, jail is a state subject, every state will have their own set of rules, but now all the states are required to follow the Supreme Court verdict, which has recently come on October 3rd, 2024. Now here, if you look at this case is important, please remember, M.K. Ranjit Sinha versus others and Union of India, where Supreme Court recognized it's a basic human right against climate change. Means when climate change occurs, your basic human right is violated under Article 21 also. And this was the same case where they also had given the verdict on Great Indian Bustard. Okay, please remember the case. M.K. Ranjit Sinha versus others case. And please remember those parts of the articles where you can say environment is connected. Fundamental rights, directive principle of state policy, even fundamental duties. So tomorrow they can ask which parts of the constitution are connected to the clean environment. You have all, you have fundamental rights, you have DPSP, even you have fundamental duty in that regard. So these are the things. And yeah, so that same judgment what as I told, that state cannot acquire all private properties for promoting common good. So that's what I told, it was a majority judgment which recently came 8:1 led by Chandrachud, where they told all private properties cannot automatically come under state control. As I told, they have told you need to distinguish between those private properties which do not have common good, those private properties which have common good. So state can acquire those private properties which have common good, not all private properties. So that was one of the judgment given by the court. And here the word socialism, again you can say it became an issue, that whether Subramania Swamy went to court asking that word socialism has to be removed from the preamble. Because one you can think the 42nd amendment 1976 added few words into the preamble. What was the three words? Socialism, secularism and integrity. So now here the petitioner's argument was that socialism is an economic doctrine, it should not be imposed on all the sections of society, etc. But here Chief Justice Sanjeev Khanna has taken a different opinion. So what he told, socialism in India does not mean any kind of economic doctrine, it just simply means the idea of a welfare state. And what is an idea of welfare state? To provide equal opportunity for all, and it does not have any kind of dictatorial dogma. Means he said don't confuse yourself with the socialism what we use in USSR. So the USSR socialism is the communist version of socialism or the Marxian socialism. The socialism what we follow is democratic socialism. What is the difference between this Marxian socialism and democratic socialism? In Marxian socialism, they don't believe in democracy, they believe in dictatorship of the proletariat, that is the working class. Here it does not include any idea of dictatorship, it believes in democracy. Second, in Marxian socialism, they believe ultimate goal is to create a casteless and a stateless society. Here we don't believe any kind of classless or a stateless society. We do believe that we want to bring class cooperation, class equality, and the state will play a fundamental role in bringing welfare of the people. In Marxian socialism, Marx believed that socialism cannot arrive without use of violence, because he told violence is the midwife of revolution. But in our country socialism, it is not a socialism that comes through violence, it is a socialism that state will establish by doing positive functions. And that is why here what the Chief Justice said, it is not an economic doctrine, it just simply means welfare state. So here you can say what Chief Justice said, it is primarily a welfare state. Here socialism means welfare state where there should be equality and opportunity for all, and is also told socialism is also considered as part of basic structure. And these are the characteristics of socialism in India or the democratic socialism: collective ownership, equitable access, wealth distribution, democratic decision making, and social services. So this does not resemble in any way to the socialism that was been used by USSR. And yeah, these are the things that you can remember. Now here you can say that the same judgment I told for SC, ST, subcategorization. So same thing, again you have to go back, Indira Sani judgment, and here you can see Article 341 of the Constitution allows the President through a public notification to list a scheduled caste, race or a tribe which has suffered historical injustice under the list of what? SC or ST. But please remember, any kind of changes in this list can be only done by whom? Parliament, through a law. So you can, Article 341 empowers the President to issue such notification, whereas Article 341 clause 2, it empowers the Parliament to make additions and deletions to the list. So tomorrow they want to remove any scheduled tribe or scheduled caste from the list, who can do it? Parliament. Any kind of addition to that list, who can do it? Initial, it is the President through an order. And here you have to remember there is a judgment. So here take, the previously court also said the subclassification of SCs violates the Article 14 based on this ruling in 2006, Punjab and Haryana High Court in Kishan Pal versus State of Punjab. Stuck means Punjab government had brought already, but that was stuck down. Why? Because that time the court's position was that you can't bring subcategorization among SCs and STs. But as I told in the recent case, that is what that State of Punjab versus Devender Singh, now the court has changed its position saying that you can bring subcategorization among SCs and STs. Now one more, this is one simple thing, right to be forgotten currently has been not still yet recognized by the Supreme Court as a part of what? Right to privacy under Article 21. But please remember, in K.S. Puttu Swamy case, the Supreme Court did declare right to privacy as a fundamental right under which article? Article 21. And please remember, it is not an absolute right, restrictions can be brought. In Aadhaar case, they said right to privacy is not absolute, and that is why they upheld Aadhaar, but they brought some restrictions. So that is what the summary of this article. But here what they have given is that in some high courts, now they have begun the trend of indirectly recognizing what? Right to be forgotten. But in Europe and all, this has been already included as part of what? Right to privacy in their jurisdiction. Now this is linked to Aligarh Muslim University case. Okay, I will just summarize this case and tell you in short what is the summary. Article 30 of the Constitution gives right to minorities to establish their educational institutions. That is one basic thing you have to know. Now what is this AMU case? So AMU was considered to be a religious minority institution when the parliament initially enacted a law and they created this AMU Act. But in 1970s this got challenged in Allahabad High Court, and that time there was a judgment called as Aziz Basha judgment. In this judgment the court said that AMU is not a minority institution. The reason they told, who has established this institution? It has been established by the parliament. It is not established by a minority community, nor it is established by any minority person, no connection to that. So this can't be a minority university, it is a central university. And they told, now they don't enjoy the benefits of a minority. But now what happened? The parliament, that time the government, they brought an amendment and they wrote in the law itself that what? This is a minority educational institution established for the Muslims. Now fast forward, in 2007, the AMU bought 50% reservation for the Muslims in post graduation in medical seats. This again got challenged in court. That time the court, the Allahabad High Court, went back and said, we have to go back to what Aziz Basha judgment is there. This is not a minority institution, so you can't give reservation. On top of that, what happened? The National Commission for Scheduled Caste and the UP state government gave notice to AMU, because for minority educational institution they need not give reservations to SCs, STs and OBCs if it's a minority education institution. But they told, since you are not a minority education given by Allahabad High Court, they told, we are giving you notice. Why? Because you have not given reservation to SCs and STs. Now they went to court again, who this AMU and even central government went to court, and now you can say government changed, the NDA came to power. Now they told, we want to withdraw the case, that we don't have any problem with the judgment given by the Allahabad High Court. But again AMU went to court saying that the court will have to look into our argument, then give a case. And only in this judgment, now they didn't declare AMU as a minority, but it has paved way for what? The Supreme Court now recently told, on what basis you will determine this minority institution, you can't go by Aziz Basha judgment. In Aziz Basha judgment, they just read a little thing. Who has established? It is parliament. They told you can't determine the minority character, because the word minority is mentioned, it is not defined. So they told it can't be determined just on the basis of who has established it. You have to go much deeper into its establishment, its character, from where you got the land, who donated the land, who played a key role at that point of time. And now they referred the case to a 3-bench judge to determine whether AMU is a minority institution or not. But they said you can't go by what they have told in Aziz Basha judgment. So if the 3-bench judge now will consider a new parameter and tell no, AMU is a minority institution, then it will enjoy the benefits of a minority education. What is the benefits you will get? One, you don't need to give reservation to SC, ST or thing. 50% reservation can be given to students belonging to that minority community. Third, when property is acquired, mandatory compensation has to be paid on market price. And also you have some freedom with respect to autonomy, with respect to regulation of these institutions. That is the benefits what you enjoy as a minority educational institution. And minority educational institution also do not come under the purview of Right to Education Act. 25% reservation need not be given to weaker section, they can give it to 50% to minority community. This is what you have to know. You have to remember here Aziz Basha judgment, the recent Supreme Court judgment, Article 30. One more is TMA Pi Foundation case. In this case the Supreme Court had told you have to determine both linguistic and religious minorities on state to state basis, not on an all India basis. Currently linguistic minorities are determined on state to state basis, but religious minorities in India till now have been determined on all India basis. Currently there are 6 religious minorities in India: the Muslims, the Christians, the Sikhs, the Parsis, the Buddhists and the Jains. Jains were the last to be declared as a minority in 2014. Since then no other community has been declared as a religious minority, and who can declare? It is the central government. Got it? So these are the, so TMA Pi Foundation case says that what? You have to determine religious minorities on state basis. The government has told they are going to implement it, but it is not yet implemented. So these are the things that you need to remember regarding what? The minority education institution ka question. Now there was one more article that had come on newspaper regarding this role of judiciary and environment, and here they had mentioned certain principles applied by the court. Okay, so for prelims you remember, one is precautionary principle. Okay, so what does precautionary principle mean? Precautionary principle, it enables decision makers to adopt precautionary measures when there is scientific evidence about environment or health hazard or stakes are high. Means you have not established a company yet, but tomorrow the court can say that you can't establish a company there. Why? Because it can be a health hazard. As a precautionary move, we are banning you from establishing any factory there. Then you have prevention principle. This allows to protect environment at a very early stage. Means already you have established it, but not early stage you start realizing that what this is causing a lot of environmental harm. So that time what they can do, that they can say that prevention is better than cure. Now stop the ongoing project, and they can ask you also that what you have to pay for whatever damages has been done. And then you can say they also what polluter pay principle. This was in Vellore Citizens Welfare Forum versus Union of India case. They are told if you are the polluter, you have to pay for it. You have to pay a compensation. Not only the government, the polluter, which industry is there, they'll have to pay for it. And one more they brought is what doctrine of sustainable development. Basically, it means that what when they are going to evaluate a particular environmental project, they are not only looking at how much jobs will be created, they are also looking at whether it is sustainable on the long run. Means there is balance between economic growth and environmental protection. And in Bhopal gas tragedy case, they brought what, that is Union Carbide case, the concept of absolute liability. What is absolute liability? You will be liable before how it was. So let us say in my house I have kept a sheet, wind blew, the sheet went into next house, it fell on his head, and I would tell it is act of God. The reason is that I didn't blow it, it is wind which blew it. Now they told no, you have to take the liability, it can't be considered as act of God. There is concept of called as absolute liability. So these are different things you will have to know regarding what precautionary principle, prevention principle, polluter pay principle, doctrine of sustainable development, and also what doctrine of absolute liability. Okay, in prelims they can ask or they might ask that. Now here, okay, fundamental duties, I think basically you know, this is nothing but recently the Supreme Court had told Attorney General recommend certain measure how we can make fundamental duties more effective. So here basically it brings that what fundamental duties were not in original part of the constitution, they were added by the recommendation of Swaran Singh Committee, 42nd Amendment 1976. And please remember, all the recommendations were not considered by the government, only few were considered. Initially there were 10. The 11th one was added by the 86th Amendment 2002, where they told it's a duty of every ward or parent to give education to children aged between 6 to 14. And please remember, here is the Verma Committee. Verma Committee looked into whether we have to make fundamental duties justified or we need to bring laws. But Verma Committee said already there are many laws to implement it. And they also told like Prevention of Insults National Honor Act, Protection of Civil Rights Act 1955, Unlawful Activities Prevention Act 1969, Representation of Peoples Act. So the Verma Committee recommended there is no need to bring any separate law for implementing fundamental duties. And if you take the 26th meeting of Eastern Zonal Council happened. Okay, so for us this will bring the topic on Zonal Council, that is important. So Zonal Council is a statutory body, that is State Reorganization Act 1956. 5 zonal councils have been created: North, South, East, West, Center. Northeastern is separate, it is Northeast Zonal Council Act 1971. And remember here how these zones were created at that point of time, it was based on natural division of the country, river system and means of communication, cultural and linguistic affinity, the requirements of economic development, security and law and order. And please remember, these are not written in constitution, these are something which they created at that point of time while making it. And as I told, the Northeast Zonal Council has been created under what? Northeast Zonal Council as a separate act. And the chairperson of Zonal Council is the Union Home Minister, and vice chairperson is chief ministers of the concerned states. And you can say that they can also appoint 2 people from their state, nominees in that regard to look after. and the CM, vice chairperson will rotate every year, each CM will get a chance, and chief minister and 2 other ministers nominated by governor of each state and 2 members from the union territories within that zone. Please remember, Andaman, Nicobar and Lakshadweep are not in any zonal council, but they can be special invitees for South zonal council meetings. And you can say zonal council is a recommendatory body, it is not something which is binding or etc. And you can have other ministers of union can also attend zonal council if required, if they are invited. In Northeast Zonal Council, you have the chairperson as the Union Home Minister, but you have the vice chairperson or deputy chairperson as the Minister of Donor, that is development of Northeast region. And you have CMs, you have governors of states, and you also have 2 experts nominated by the president in that regard. So here you can say these are the different zonal council, which I think you would have already read in Lakshmikant. And the last topic for today is special category status. So if you take why this again has come in news, because this Bihar and Andhra Pradesh are demanding special category status. So remember, there is no provision in the constitution which speaks about special category status. For the first time the special category status was mentioned under what? The 5th Finance Commission, okay, 1969. And then you can say Jammu, Kashmir, Assam, Nagaland and all the northeastern states, even Telangana had received special category status, but what happened later, the 14th Finance Commission took away the special category status. They told only northeastern states and this Jammu and Kashmir, they should have special category status, so they removed it for Telangana, and they told no new more special category status has to be given. Which commission? 14th Finance Commission. And you can also say that what is the, on what basis they will determine the special category status will be given. So this was given by the Gadgil formula, okay. So what was the formula here? That state should have a hilly terrain. Second one, low population density. Third one, strategic location along the borders. Third one, state should be backward in both economic and infrastructure. Fifth, non-viable nature of the state finances. These were the criteria to determine the special. These are not mentioned in constitution based on Gadgil formula given back then. And now you can say that what is the advantage you get. So for other states, if you have to give 60-40 ratio funding split, here it will be 90:10. And other benefit what you have is that you will also get important concessions in terms of customs, income tax, corporate tax. Another thing is that the money what they have given to you, if you do not spend it that year, it does not lapse. You can continue it for next year. For other states it will lapse. And 30% of center's gross budget, totally in the center's budget, 30% will be allocated for what? Special category states. So that is why you can say Andhra Pradesh and Bihar are asking for, but the center has not yet given. They are telling we can't give. Why? Because the 14th Finance Commission has told not to give. If it is given, other states will also start demanding, like Odisha will also start demanding. Okay, we will stop here. Again we will schedule one more session. It will be day after or something like that. We will complete the other half of the topics what are there in polity. Still some topics are there. So means I think still I think we will need a 2-hour class next session, because this is only 1 hour. We will have a 2-hour class. We can complete the entire polity based current affairs. So this is 1 year current affairs linked to polity, which had come in newspapers. So the idea here is that you have to do it for other subjects also, because polity is my subject. I will do current affairs, but I can't do current affairs of environment or etc. So that you will have to do. IR I will do. IR based current affairs I will do in one session. The entire current affairs, what is in use in IR for 1 year. For other subjects you also have to do, means once you are thorough with your basics, you have to complete 1 year's current issues. That's what I told. Current issues matlab it can also be similar to what you have already read. Okay, why they will ask questions in these areas? Because they have been in news for some or the other purpose. So UPSC won't randomly ask topics, they will ask topics which are in news. This document is already there in the Telegram channel, or if you want I will again share only the prelims part of it in the Telegram channel. You can download from there. Okay, so again we will have a session in what you can say day after tomorrow or something. I will know the time. So next session won't be evening, it will be in the morning. Okay, it will be morning, I think on Thursday, that is 8:30 to 10, something like that. I think before your GS classes will start.